Number 35, People v. Johnson.
After your honors, can I reserve 2 minutes for rebuttal?
You may, 2 minutes.
Paul Watkins representing the defendant appellate Tyquan Johnson. As the court knows, this involves the first 3 to 4 levels. On the first level, the police officer needed an objective, credible reason to stop and approach my client.
Let's talk about what happened here. What did the appellate division decide as to which level was involved?
Well, that's the problem, Your Honor. As I pointed out in my brief, they just went ahead and gave a blanket decision. They didn't specify what level was involved. The trial court said level 1, 2, and 3 were all involved, and the appellate division in their decision just stated, we find that the trial court was correct, without specifying what level. And I pointed out some of the cases they cited don't even apply to the situation. So I don't know the answer to that, Your Honor. My brief and my request to this court was all 3 levels. Now, getting back to the level 1, this court has said that you need a level 1 applies to
I mean, the appellate division does say.
I'm sorry, Your Honor?
The appellate division does say that the evidence at the hearing established the action taken by the officer was justified in its inception, which must refer to step 1, level 1, and at every subsequent stage of the encounter leading to the arrest, which must mean 1, 2, 3, and then arrest.
Because my point, Your Honor, was that the cases, if they didn't specify what case they said goes to what level. So, I mean, all 3 levels are at stake here. It's just
But then it says generally de boer.
Excuse me?
But then it says generally de boer, people v. de boer, so.
Right, so.
And de boer sets out this framework.
Yes, so I'm not sure, all 3 levels are at stake, Your Honor, here in the appeal.
No, I don't disagree with you on that, but let me ask you this, just to clarify the record somewhat. Is it your position that the testimony by the officer at the hearing is that he stops and is curious because he observes this car parked in this particular neighborhood and the person moves from the driver to the passenger seat and then makes a hand movement back to the driver's seat? Is that what triggers that first level 1 approach? Is that the way you read the record, or is there more that the officer has observed?
No, Your Honor, except whether the area was parked in, I mean, the officer did say they were because of an uptick of crime, but then that's not the reason he gave when he testified as to why he decided to approach my client for the level 1. It was, as you pointed out, my client simply in a parked car, moving from the driver's seat to the passenger seat, and then moving back his upper body, not his hands. Police officer did not see his hands, and contrary to what the people said in their brief, my client did not reach into the back. Officer just saw him move from the driver's seat to passenger seat, lean back, and decided to pull over. One other thing that I thought was very important is the fact there's nothing in the record to show my client made any moves because he was aware of the police officer. No other level 1 cases with parked cars, the police officers pulled up beside, no parked car, they approached a parked car. Here the officer said he was 50 feet behind in his car, pulling up behind my client in a parked car when he saw the movement. So the supposition or moving from the fact that my client somehow did it because it was furtive or he saw the police officer, there's nothing in the record to show that.
So doesn't that make it a level 2 then?
Well, Your Honor, no, the level 2.
If he's not responding to the car pulling up behind him, and the first interaction he has with the police officers once they're outside the car. So haven't we just skipped right to level 2 in this case?
That's correct. My position, though, Your Honor, is that the police officer should just keep on going. There's no reason for him to stop his car, because all he did to stop the car was see my client move from the seat. He should have said, oh, nothing wrong with that. People move over the seats all the time. I'm
He
going
didn't
to keep on
stop the
cruising
car.
around from someone who's really doing something
I'm
bad.
sorry, he didn't stop the car, right? The car was stopped, was parked.
Yeah, I'm sorry. I
You
meant-
mean follow him, is that what you're talking about?
No, no.
I'm
Or
trying
did
to-
you mean the officer shouldn't have stopped his car?
That's correct.
Ah.
Oh, sorry, I missed.
I'm sorry,
Right.
I
My
misunderstood,
client's-
thank you.
yeah.
But he did
I
more
can't
than stop his
say
car.
This car, that car,
turned
exactly
The o-
right.
The officer stopped his car and he turned on his lights, didn't
Yes.
he do that? Now, that to me, I don't know, there's something interesting to me about that that suggests that some sort of criminal investigation is underway. That itself seems to me to have a level 2 sort of feel to it. What's your take on the lights?
My take, Your Honor, is what the officer's purported reason, said, I wanted to check what was going on. Why he didn't turn on his friend headlights, I don't know. Why he turned on overhead lights, I don't know. But no, there's,
But I think the question is that act, pulling up behind, turning lights on, so I guess some of the interior of the car is illuminated, is that in itself a level 2 interaction?
well, Your Honor, I would say the level 2 interaction, according to what the cases say, you have you can go up and ask someone a question that makes them think that he's under
It's an
criminal.
interaction between
Right.
the police and the
Right.
the citizen.
In my brief, I tried to go and differentiate why I thought the level 1,
But
level 2.
but here, there's no actual interaction until both are out of the cars.
That's correct. My position in this is that we skipped over level 1 entirely. If he had gone ahead, stopped the car, my client's in the passenger seat, walked up and said, what's going on? Maybe. He didn't do that.
What did he ask?
He immediately went ahead, and when he stopped the car and got out, and this is important, he got out just as my client got out. My client gets out, the police officer says, well, he's adjusting his pants. I thought that might be where he puts a weapon, so I started to follow him.
And the question was, do you have a gun? Wasn't that the question? The
Yes,
first-
in, Your Honor, as I point out in my brief, and this is very unique, in all the level 2 cases I've had, this is the only one I've seen where the client did not have a gun.
Yeah, but if he had a gun, would the interaction have been okay?
I'm sorry, Your Honor?
So let's say he had a gun, not this case, hypothetical, same facts. He has a gun. Would your view be then that was okay?
No, it wouldn't.
So what's the difference if he
The
has a gun?
difference is then officer cannot go ahead and start saying, well, there was a bulge. Or there was some other click, there's a click of a weapon. Weapon did not exist. The only thing that he has to go on is my client pulling up his pants when he gets out of the car.
So isn't it easier to just say that at level 3, there's no articulable reason why the officer should have put hands on the defendant, and then it doesn't matter what happened in level 1 and 2? Because there's no justification for that frisk at 3?
Oh, yeah, the way you honor, that's fine. I mean, I'm just covering all my bases. If for some reason you say level 1, yes, level 2, yes, level 3, no, that's fine with me. Either, any level where you find he shouldn't have done it, the indictment should be dismissed. If you want to skip all the way to level 3, that's good. I'm just pointing out that each level, and just to make sure that everything's covered, I may argue
There
for
is
each
no
level. I actually think the level 1 argument,
Counsel, your argument is basically, there was no justification at any point for any of the conduct on the part of the police officer
That's
as it
correct.
relates to your client.
yep, and Your Honor, the other thing is,
So let me follow up on Judge Troutman's point there. So your first point was, he sees the movement, the officer, excuse me, sees the movement in the vehicle, sees it's parked, sees the movement in the vehicle. He should not have, the officer should not have stopped his own car. He should have kept going.
that's
That's
correct.
your point. Okay, that's your view. All right. And let's say we didn't agree with that. Once the gentleman got out of the car and he adjusted his belt, that the officer should not have followed him. Is that also your view at that point?
No.
Okay.
My
He
view
could
is,
follow him?
what he could do for level 2, and this is what he did, he
If
said,
the officer's correct at level 1,
right,
he can follow him because of the belt adjustment and what he's observed in the car?
what he can do for the level 2 is say, hold up, what you did, and then follow him. Because on the level 2, but then he asked a very pointed question. Do you have a gun? And my client says no, which is right. And then that's when the level 2 ends. He's followed my
He
client.
could have followed him. He could have tried to stop him physically by getting in front of him. And he could have asked this question about the weapon, since that was his concern when he first observed the movement in the car. And once the defendant says no, what does the officer do? He just walks away?
That's correct.
And the defendant keeps walking? Can he follow him?
Yep. What do you, yes, Your Honor,
Can he
that's
follow him?
correct.
Can he follow him?
Yes.
Let's
What
say he
happened-
doesn't believe him, and he wants to follow him.
I'm
You say
sorry-
yes.
Sorry, Your Honor?
Let's say the defendant has said no, the officer says, okay, I have to stop asking you questions, and I can't prevent you from walking away. You have a right to walk away from me.
Right.
Can he follow him?
Well, he did. Yes, what he did was,
Well, follow him without touching him, without saying anything else. Can he just surveil?
my position is, the level 2 inquiry, once he went ahead and asked the pointed question,
Yes.
do you have a gun? My client says no. Level 2 is done. Because he asked a pointed question, got a no. Instead, he went ahead and took it up to level 3 by keeping on following him and getting next to him, and then asking him, you look nervous. And my client says, no, I'm not nervous. All right, well, I'm going to frisk you. So then he steps in front and starts frisking my client based on the fact only that my client says, well, I'm not nervous.
So what made it level 3? Was it the following and saying you look nervous, or was it the actual pat down that made it level 3?
Well, Your Honor, that what I did in my brief, I made the difference between level 3 approach and the frisk. Level 3, you go ahead and you have a suspicion that criminality is afoot, that there's criminal activity going. Then you can do the level 3 and you stop and you ask very pointed questions, and then, which the officer did. And then just based on the fact, you walked up to my client stops, you look nervous. My client says, no, I'm not nervous. And he says, all right. And then he steps in front, stops him, and does the frisk. My point is, I differentiate my brief between what a level 3 is and the actual frisk. I mean, as a practical purposes, level 3 and frisks, it's hard to differentiate. I've never seen a case where someone's level 3 inquiry and then they just walk away. Of course, they're going to frisk them if they think there's something wrong. But there is a difference between the level 3. The level 3, you can go ahead and stop and detain if you have reasonable suspicion the felony happened. Then, if you want to do a frisk, you need to have something to go ahead and do a frisk. Now, one thing that I thought was interesting in this is
Counsel,
that...
before we get to that, do you see that there's a level 1 encounter at all here, or this goes right to 2?
I'm sorry, Your Honor?
Do you see a level 1 interaction at all here, or does this go to right to a 2?
Well, Your Honor, you go right to 2. Level 1, you walk up and say, what's your name, how's it going?
Some
Never did
inquiry,
that.
right.
Right. This would have been a level 1 situation, like I said. My client had changed from the driver's seat to passenger seat. Officer walks up to the window and says, what's going on?
Right.
That's a level 1. Never happened because the officer says he got out of the car.
Understood. And so your argument isn't that by pulling up behind the car and shining the light into the car to whatever extent, that's a level 1 encounter?
Well, no, Your Honor. Just because the way the cases are, the officer gets to ask, some questions about pedigree, for a better, term. What's your name? How you doing? What are you doing here? I think just actually, if for some reason the lights got turned on my client tried to drive away, it'd be a different story. But no, I don't see the lights. The lights are just what the police officer said I wanted to see inside.
Why is it a different story? I thought people could just walk away.
I'm sorry, Your Honor?
Why would it be a different story? I thought you have the right not to engage with a police officer. You can just
Well-
walk away or pull away in your example.
The
It'd
lights...
be hard to do. He's got to get back in the driver's seat.
I'm sorry, Your Honor, if you had not turned the lights on,
No, I thought you said it would be different if the lights were turned on and then the defendant had pulled away.
Yeah, something like that. I mean, the lights went ahead and instigated him, and then we'd be out at the DeBoer level. We'd be into what does a police officer need to actually follow somebody. I mean, I view the overhead lights as just the police officer, as he said, just wanted to look in the car. My client, wasn't trying to drive away, and the lights didn't stop him from driving away. According to the police officer, it was just for the officer to be able to see inside.
It was 5 o'clock on April 13, 14, 15.
It's
wasn't
almost exactly 8 years ago.
it? Yeah. Wouldn't it be light out at 5 o'clock?
Yes.
Okay.
Right, that's the one thing I looked at. I mean, if it's dusk, he's 50 feet away even makes less sense. But no, it wasn't. It's just like,
It's almost 5
hour
o'clock
from
now.
now.
Speaking of which, Counselor, your time is up.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Marty McCarthy for the respondent. To take Justice Troutman's question at the beginning, the appellate division had to have decided what was decided at the trial court. The Fourth Department religiously follows this court's rulings in Concepcion and LaFontaine. So the trial court found that this began as a level 1 encounter. It went to a level 2 encounter, ultimately ended at a level 3 encounter and subsequent.
So we're bound by that.
Well, the appellate division felt bound by that, and that's what they decided. That's why they worded it that way. It wasn't artful. I will certainly concede that point. But that is what they were saying when they said that. To deal with the issue with the lights, I just want to make sure that we're talking about the same set of lights. There's 2 set of lights on top of a police car. The first set are the ones that rotate, the ones that you see when somebody's pulled over on the side of the road for a traffic stop. And then there's a second set of lights, which are just white. He indicated he activated the overhead lights, not the emergency lights. So the
These
lights,
are the ones that strobe on?
those are the emergency lights. And he indicated he activated the overhead lights. So this wasn't a scenario where what he was doing was pulling up and effectuating a traffic stop of a stopped vehicle. And this wasn't a stop of a moving vehicle.
He was doing it to be able to look in.
He was doing it to be able to look in. And there was not a whole lot of indication of what the lighting conditions were. It
Okay,
was
so
April.
what about someone in a car, moving from one seat to another, getting out, pulling up their pants, caused the officer, or justified the officer taking the actions that he did here?
So I'm going to break that up, okay? I'm going to start with because the way the court analyzed it was the actions of moving back and forth in the car were unusual.
We didn't move back and forth.
No.
You moved from the driver's seat to the passenger seat and then reached back over. That's not jumping and moving back and forth.
It's at least one jump with one sort of
Reach over.
in
I
this
moved
direction.
to the passenger seat. Oh, I forgot my cell phone. Or I dropped my cell phone as I did that. Let me go pick it up.
That's unusual.
Well, how is that unusual?
Well, I'll give you
People
an
moving cars, it's a huge car.
I'll give you an example of People versus Perez, where
Oh, my favorite, yes.
I know you're familiar with that case, Your Honor. The officer in that case was standing in the hallway area, and the defendant in that case came out of the elevator, saw them, and immediately went back in the elevator. That was unusual, right? It just has to be an objective, credible reason.
But
Can
here,
we get to level 3, though, honestly, because this is what's troubling me, right? He's adjusting his pants, or his pants are unbuckled. Usually, the argument is, you're putting a gun into your waistband to secure that weapon. Clearly, you're not securing it in pants that are unbuckled. So, what other basis of fact do you have that would justify this police officer doing the frisk for a level 3? I mean, I think we could argue about 1 and 2 and whether it's affirmed findings of fact and so on. Was it a level 1? Did we jump right to level 2? But let's cut to the chase. How do you justify the level 3?
Well, let me stop you there for 1 second, because we're done with level 1, right? I don't think there's any more questions about level 1. So then that was the reason why he stopped the car.
Perhaps.
No promises.
Perhaps.
no,
You should answer Judge Sigurd's
Three.
And you
Three.
can certainly ask me questions, right?
She
So-
asked you level 3.
Yeah, and I'm going to get there in 1 second, because I'm not sure if we're talking about, when we say level 3, I want to make sure we're talking about the same thing, right? So that justified him to stop the car. Let's just agree on
The
that.
car was
first.
stopped, the car stopped, right? There
Yep,
was
so
no, there was
he-
no action of the police officer stopping the car.
Assume
like,
everything's
okay.
justified
Okay.
until he...
So he gets out, right? And what the court found was not that the pat frisk was pursuant to level 3 DeBoer. What the court found was this was a Terry frisk pursuant to level 2 based on the officer's familiarity with the defendant. He had met this defendant several times before, and when he encountered him on this particular occasion, he was very nervous, right? His heart was racing. Looked like
Anybody
he-
would be nervous when the police come up. I'm nervous when the police come up.
Well,
That's a normal human reaction.
I would be too, but based on the record, it appeared that what the court found was that in this particular case, he was nervous where the other times he was not, right? And that was why he talked about the fact that I dealt with him before, and he was nervous this time, right? His heart was racing. So as he approaches him, as part of the level.
Maybe his heart is racing from moving from the driver's seat to the passenger seat in the Ford Explorer, reaching over, walking out, moving
Yeah.
right along.
Yeah, that's a
I
possibility.
mean, he said he's not nervous.
And that was the thing, he's not nervous,
The
but.
point is, isn't that behavior just as equally innocent behavior?
Well, when it comes to, when you look at the authority for conducting a Terry frisk, right? A police officer doesn't have to wait for the defendant to pull a gun out, right? He could,
So here, you're saying his heart was beating fast, he seemed nervous, so the officer had the right to search him.
he conducted a
Pat frisk.
frisk. He
Well,
conducted a
it's
pat
an
frisk.
intrusive thing to do to a citizen walking on the street. Is it your suggestion, anytime a police officer sees someone and they say that person is nervous, they have the right to pat that person down?
It was based on the police officer's previous encounter with the,
Okay, there was no crime that had been occurred. He wasn't responding to a call.
no.
So, and he didn't say he witnessed criminal activity prior to making the actual encounter with the defendant, correct?
No.
It's just, he's nervous, so I'm going to pat him down.
It was him being nervous, it was the conduct of, so the question, I think it was, I don't know if it was Judge Garcia, how do you secure a gun? Well, you secure a gun, the testimony was you secure a gun, or Judge Singas, I'm sorry, by putting in your pants and tightening a belt, which is what he was doing.
His pants were loose. How,
He- When he
Judge
got out of
Singas
the,
pointed out, it is always stated, yes, they secure it in the belt, with the belt secured. In this instance, accepting the findings of fact, his pants were falling down.
When
How
he-
could he be holding a gun?
when he got out of the car, his pants were down. As he approached him, he tightened his pants. So,
Counsel, I think the nature of the question is that logically speaking, in order to secret the gun, the pants have to be tight first. You can't put the gun in and then secure the belt and close the pants. That just makes no sense. That's illogical.
well, the gun couldn't have, given physics, he probably wouldn't have had the gun in his pants when he was sitting down.
Yeah, and
You
given
would agree with
physics, he
me.
wouldn't have had the gun in his pants before he had buttoned his pants and closed his belt.
But the other fact is here's the defendant, and here's the officer's behind him, not in front of him. So he's not coming this way. If he had come this way, you can clearly see his hands, clearly see anything in his hands. He can't see anything in his hands. The conduct in the car of reaching, from going from the driver's seat to the passenger seat and then reaching back to the driver's seat, which he described as either secreting something or retrieving something. In this
So
case,
anytime you exit a car, instead of out of your own door, you go to the other side, you're secreting something, that's suspicious?
It
Door
was-
could have been broken on his side.
it was potentially suspicious. And again, once he got up to him, right, to me, the fact that sort of tips the analysis, had he gotten up to him and he had said, hey, how you doing? And he was not nervous, then you wouldn't have a basis to escalate.
Yeah,
It
but you
was-
see, now, this is why you're wrong about that level 1. Because why is he approaching him? There's nothing to suggest that he should be approaching this gentleman. That's the argument, anyway.
Well, that's his
The man
argument,
is moving in
yes.
the car, he exits the car. You can correct me if I'm wrong. As I understand the record, the officer doesn't testify that the defendant exited the car because he noticed the officer was coming towards him,
I don't believe
even
that-
though someone can walk away from an officer.
And you've said that before, and you're correct.
So what,
But
why are you
that's-
going up and stopping the man?
But the whole idea behind level 1 just requires an objective, credible reason.
And that's my question, how is this people move around in a car?
So in Barksdale, the defendant in
Oh, my
Barksdale,
other favorite case.
again, I'm bringing out all your hits here.
I know. All the
In
hits, yes.
Barksdale, the defendant was just standing in the lobby. That's all he was doing. He wasn't doing anything other than standing in the lobby, and that was justified as a level 1. Here, he's doing, there's a little bit more, what you would call surreptitious activity
Standing in a
here.
lobby, who knows if he should even be there, but there's no suggestion he's not properly in his car. It's not like the officer thinks that he has stolen this car or vehicle.
Well, there's nothing in the record one way or the other
And
as to
counsel,
whether.
on this point you made on, he knew the defendant, my reading of the Supreme Court decision is that, the suppression court, is that that just goes to nervousness. It's not like he knew him to be in a gang or he carried a gun past. It was, I knew him and he seemed nervous now.
Yeah.
I mean, does that get you a pat down?
Well, the nervousness in the sense of, at that point, he was nervous, and the officer feared for his safety as a result of that. So it was a
But it has to be a
baseline.
reasonable fear, right? And all
Well-
he's got, even with the past knowledge, is he's nervous, and I think we've been through enough, the pants adjustment, but those two things, right?
Did he ever see a bulge?
Well, he was always, in that sense, he was, when he was approaching, he was behind him. When
Right.
he was in the front, I don't know if I don't believe the record reflects whether there was a bulge.
What happened to the other officer? He stayed in the car?
I don't think the other officer testified, and there's no real.
No, he didn't.
There's no real indication as to what he did or didn't do. Any other question? My time's
Thank you,
up.
counsel.
Thank you.
Just a couple of points. The counsel pointed out the Barksdale case where a defendant saw a police officer and then, moved. The issue here is that there's nothing in the record that shows my client made any moves in the car because he was aware of the police officer. Police officer didn't approach him from the side, didn't come straight on. And so the Barksdale case is not on point. There's so many other explanations that could be had for moving in the car. I can think of that maybe the door didn't open correctly. Maybe he looked and saw someone coming down on a bicycle on the wrong side of the road and decided that he was going to try to move out of the car to the passenger seat. There's so many innocuous reasons, but the main thing is there's nothing to show that he knew the police officer was behind him, and so to say that he made the move as a furtive or in response to police, there's nothing in the record to show that. Now, the thing about the officer and the nervousness, yes, the officer did testify that he had recognized my client. Under what circumstances, we don't know. Was my client an informant? We don't know. Was he helping the police when he saw him? We don't know. So to say that somehow, because he saw my client before, he knew he was nervous, that's not supported by the record. And as Justice Troutman, you pointed out, are we going to start letting police officers stop, frisk people just because they're nervous when they meet the police? I don't think we want to do that.
Well, but I thought the argument was that it's from the moment the officer sees this car. It's everything that has led up to that moment.
Well, Your Honor-
That supports, right? It's not just, this may take it over the top, but you have to look at the totality of the circumstances.
Well, Your Honor, this is not a situation where the whole is greater than the sum of the parts, because each of the parts have to be examined in their own separate area. As we don't get to level 3 if you find that there was not enough for level 1. And so when you go to the level 3, you have to have exactly what is needed for that under the law. And for that, you need to have enveloped in a felony. Now, I had one other issue about now, what you said, Justice, about the other officer, I was going to point out that if Officer Pike was really, really concerned about his safety, that he had to frisk my client, where was the other officer? There's nothing in the record that shows Officer Pike said, yeah, I called Officer, I think, Schultz to come over because I was worried I want to have backup. Nothing there. If he's really, really concerned about his safety because my client allegedly had a gun or a weapon, why didn't he testify? I was so concerned. I had the other officer come over. We don't know where the other officer was. They never called him to corroborate any of this testimony. And so your point, Your Honor, is very correct. Where was the other officer during all this time? Officer Pike thought that he was in danger for his life and had to frisk my client only because he looked nervous.
How much time has passed? These are quickly, right? It's a fast-paced situation, as many of these interactions are.
Well, Your Honor, that's not in the record. I mean, there's nothing, no one asked the police officer, what time did you stop? I mean, other thing is, it's unclear to me why someone didn't put the police report into evidence, because they tried to go ahead and, impeach the officer with it. With the police report in evidence, might be answered the question. I don't know why that didn't happen, but it didn't. I do not know the answer to the question, but just from a very practical point of view, if you have another police officer in the car and there's an encounter with somebody that could be suspicious or have a weapon, that officer's not going to just sit in the car. He's going to be somewhere doing something. No testimony from that officer, no testimony from Officer Pike about it.
Thank
To
you,
me,
counsel.
that does it.
We'll leave it at that.
Thank you, Your Honor.